Welcome to eGestalt's webinar titled How to Be Compliant with the New HIPAA Hi-Tech Act Best Practices. Today's presenters are Anupam Sahai, co-founder and president, eGestalt Technologies, Inc., USA, and Rebecca Harold, founder and CEO of Rebecca Harold and Associates, LLC, also known as the Privacy Professor. Anupam is an accomplished management, marketing, and technology leader with 21 plus years of experience directing teams to develop and launch globally renowned products generating up to $350 million annually. Prior to eGestalt, Anupam was Vice President Marketing for Ixia Inc. Rebecca is CEO of Rebecca Harold and Associates, offering information security, privacy, and compliance services and products. In addition to consulting and being an MSIA, Master of Science Information Assurance, professor for Norwich University, Rebecca has worked in the healthcare industry for over 2 decades, has published 14 books, over 200 technical articles, and is a member of numerous advisory boards. If you have any questions, please send them via the questions function in GoToWebinar, and we will address them at the end of the presentation. If you would like a copy of the presentation, please send an email directly to Anupam or Rebecca. Their contact information will be given at the end. Thank you, Anupam and Rebecca, for presenting, and I'll turn the webinar over to you now.
Thank you, Mike. I am happy to have an opportunity to share information with you today about HIPAA and Hi-Tech compliance. Today we will cover a HIPAA overview, the proposed HIPAA changes, including the new proposed responsibilities for covered entities, as well as the new proposed responsibilities for business associates, the additional enforcement that is happening now, some of my real-world experiences, common risks and problems that I found over the past decade of doing HIPAA work. Then Anupam will provide a secure GRC overview, unification of compliance management and security. He'll discuss how automation and proactive monitoring can help, and then we'll provide conclusions and a summary and allow for questions and answer as time allows. Here is a very brief history of HIPAA and Hi-Tech. It was passed way back in 1996 and was originally called the Kennedy-Kassebaum Act, and then it became known as HIPAA. And then we have the noted events shown on the screen that occur right up to today. So HIPAA has been around for over 14 years. Unfortunately, very few organizations that I found have done very much to truly comply with all of the security and privacy requirements. But with the inevitable and coming increased enforcement activities, this should change. The overall goal of HIPAA is to provide insurance portability, fraud enforcement, and administrative simplification for the healthcare industry. Now, there are 4 administrative simplification subsections or rules, which include mandates for the security and privacy of personal and confidential healthcare information, referred to as the privacy rule and the security rule. Standardized electronic transactions and code sets is also one of these subsections, and it's referred to as the electronic transactions and code sets rule, and national identifiers, referred to as the unique identifier rules. Now today I will focus on the security rule and the privacy rule issues, focusing on the changes to the 2001 and 2003 original rules that are contained within the Notice of Proposed Rulemaking, which I'll call the NPRM throughout the presentation, that were published during the first part of this past July. Now, the NPRM significantly modifies the definition of a business associate to include a health information organization, e-prescribing gateway, or other person that provides data transmission services with respect to protected health information, or I'll call it PHI, to a covered entity, and that requires routine access to such PHI. And it is also a person who offers personal health records to one or more individuals on behalf of a covered entity. The NPRM specifies that entities that manage the exchange of PHI through a network, which would include providing patient locator services and performing various oversight and governance functions, now fall within the definition of a business associate. This is a much broader definition that had existed previously. It also expands coverage to subcontractors of the BAs. Now, this expanded definition embraces literally an estimated 3 to 5 million more organizations that to date have not really been paying that much attention to HIPAA and HITECH requirements. Most of these businesses are small businesses that don't even have a formal information security or privacy program in place, much less anyone assigned to ensure compliance. Exceptions would be that entities that act only as conduits for the transport of protected health information, but who don't actually have access to that information other than on a random or infrequent basis. They are not considered as business associates under the NPRM. Now, that could change when the final one comes out. However, if entities manage the exchange of PHI through a network, including providing patient locator services and performing various oversight and governance functions for electronic health information exchange, then they have more than just random access to protected health information. So they would fall within this new expanded definition of a business associate. We also have expansion of BA requirements. Now, most of the NPRM's many provisions include direct application of HIPAA to business associates. In accordance with HITECH, the NPRM requires that BAs directly comply with the HIPAA security rule provisions that mandate administrative, physical, and technical safeguards, and that they also adhere with the terms of both their business associate agreements and with HITECH's privacy-related requirements. BAs that violate these obligations are subject under the NPRM to the same civil and criminal penalties as the covered entities. Most business associates today have not really been that concerned with the provisions of the security rule and the privacy rule, focusing only on the BA agreement. And then after February 2009, they started thinking about breach response. Now they really need to start putting processes and controls in place to limit disclosure of PHI according to the terms of HIPAA under the security rule and the privacy rule. And they also need to make sure that only those with a business need have access to PHI to meet the minimum necessary requirements. In a somewhat surprising move, the NPRM also extended HIPAA's reach to subcontractors of BAs, making them liable for privacy and security violations to the same extent as BAs. The NPRM basically revises the definition of BA to include BA subcontractors and requires BAs to execute business associate agreements with their subcontractors. The HITECH Act established 4 tiers of penalty amounts to correspond with levels of culpability. Now, the lowest penalty tier addresses situations where the covered entity or the business associate did not know and by exercising reasonable due diligence would not have known of a violation. Then you go up to the second category, and it applies to violations due to reasonable cause but not due to willful neglect. Now, the third and fourth categories apply to circumstances where the violation was due to willful neglect. That is, at Tier 3, corrected within a certain time period, and in Tier 4, willful neglect is not corrected within any time period. Consistent with the changes under HITECH, the proposed modifications would make clear that the HHS, or Department of Health and Human Services, will investigate any complaint filed when a preliminary review of the facts indicates that there is a possible violation due to willful neglect. Also, under the proposed modifications, the HHS will conduct a compliance review to determine whether a covered entity or business associate is complying with HIPAA and HITECH requirements when a preliminary review of the facts indicates a possible violation due to willful neglect. You'll notice I'm saying willful neglect a lot because this is becoming a key factor in determining what the penalties and fines will be. The NPRM includes a few useful examples of willful neglect, basically cases where organizations know they're not in compliance and are choosing not to even try to get into compliance. The NPRM proposes to replace the term individually identifiable health information with protected health information to better reflect the scope of the privacy and security rules and then to be able to use just one term instead of 2 throughout. Now, this will likely result in the need for organizations to change their policies where they've specifically used the term individually identifiable health information. Now, I think this is a good thing, though. Using both individually identifiable health information and protected health information has confused many covered entities over the years. And in the past year, as they've been working on breach response plans, most BAs that I've spoken with have been really confused about what the difference was. So this will help to simplify this topic. The proposal to remove protection of PHI for individuals who have been deceased for over 50 years has many people and privacy groups concerned, though. The indicated intent was to allow for more research to occur. However, many are concerned that the memories of loved ones will be desecrated, if you will, if secrets long buried are dug up for the world to see if they are no longer protected after this 50-year period. The definition of electronic media was updated in the NPRM. Now, this is important because of how quickly the original definition became outdated as new technology emerged. For example, now intranets are considered to be a type of electronic media. It also applies more clearly to voice communications over phones and over networks. Now, this will allow for the rule to apply more easily to new technologies that we haven't even thought about to date. Several changes in the NPRM will require all entities that must currently provide notice of privacy practices, or NPPs, to the patients to now update them. One update is to ensure the individual is aware that he or she has the opportunity to opt out of receiving subsidized treatment communications from care providers. The NPP must also include a statement informing individuals that the provider may send treatment communications to the individual concerning treatment alternatives or other health-related products or services where the provider actually receives payment from a third party in exchange for making those communications. And they have to give individuals the opportunity to opt out from receiving those types of communications. The NPP must also now clearly indicate that the patient can also opt out of receiving fundraising communications. In general, covered entities must disclose whenever they are getting pay related to their communications. Covered entities provide notice that most uses and disclosures of psychotherapy notes and for marketing purposes require an authorization so that individuals can be made aware of all situations in which authorization is required. The NPP must also let patients know that if they pay for their health care item or service themselves, in other words, paid out of pocket in full, then they have the right to restrict information about the care or service from being communicated to their health care insurer in many to most situations. So this is a significant change as well. In accordance with HITECH, the NPRM proposes to modify the definition of prohibited marketing to include certain health-related promotional communications if the covered entity that is making the communication receives financial compensation from a third party. CEs may not receive compensation for communications made to carry out healthcare operations without patient authorization, except in limited circumstances such as refill reminders. But treatment-related communications that are paid for by a third party are permitted without patient authorization if the communication discloses the financial compensation and also provides the individual a clear and conspicuous opportunity to opt out of receiving future subsidized communications. The NPRM also requires that any fundraising communication sent to an individual provide a clear and conspicuous opportunity to opt out of receiving any further types of fundraising communications. HITECH requires covered entities to comply with an individual's request not to share information with the individual's health plan if the individual is paying the full cost of the service to which the information relates. Now, implementing this provision, the NPRM clarifies that covered entities must permit individuals to determine which healthcare items or services a restriction applies to, and that covered entities may not require individuals who wish to restrict disclosures about certain healthcare items or services to then restrict disclosure of PHI about all types of items and services. The NPRM proposes many new requirements for covered entities, or CEs. Now, one of significance is that they must revise business associate agreements. They must be changed to make reference to HITECH obligations, to include breach notification requirements, to include information about EHR disclosures, to list restrictions on disclosures for treatment paid out of pocket, and also to give the business associate right to terminate their business associate agreement if the covered entity violates HIPAA requirements. CEs will also need to inventory their business associate subcontractors. Now, as part of this, covered entities will need to know who their business associates all are. Then they need to know which of those business associates have subcontractors. Then they need to make sure that they require their business associates to have subcontractor agreements in place. Now note, the covered entity is not required to directly contract with the subcontractor themselves, though. As another new responsibility, CEs will now need to be more proactive to ensure BA compliance activities. The NPRM removed an exception, and now it specifically states that the covered entity remains liable for the acts of his business associate agents, regardless of whether the whether the covered entity has a compliant business associate agreement in place. So that's pretty significant as well, to indicate that there will remain liability on the CE's part. Business associates now must not only generally comply with the privacy rule and security rule, but they must also ensure their subcontractors are also in compliance, as well as have a formal contract with them outlining their information safeguard obligations. Now, this can be done using a contract similar to a BA agreement. Many of the BAs I've spoken with are now making plans to work with their subcontractors to more directly help them to understand their obligations and what they need to do. The BAs are concerned that most of their subcontractors today have not really known anything at all about HIPAA requirements. Most BAs are still working on getting their breach notice plans created to coordinate with their covered entities. Now the NPRM proposes that they also need to have breach response plans with their subcontractors and to establish the ways in which the subcontractors will notify them promptly when a breach occurs. Some of the BAs I've been working with are basically providing copies of their breach response plans to their subcontractors and then working with them and asking them to update them and modify them to make them fit their own organization. It's important for BAs to proactively ensure that their subcontractors have appropriate safeguards in place. If the business associate learns of a pattern of activity or a practice that the subcontractor is doing that creates a material breach or violation of the contract, then the business associate would be required to make reasonable attempts to help ensure the subcontractor corrects the non-compliant situation. Now, if unsuccessful, the BA would then be required to terminate the contract if it's feasible. In addition, a BA would be required to furnish any information to the Department of Health and Human Services as they require to support a HIPAA compliance investigation. Now, this is making both BAs and their subcontractors a little nervous, since in many cases they are both starting from scratch with regard to these kinds of compliance activities. Several significant enforcement activities are happening right now, and more are anticipated very soon. BAs are directly liable for breaches right now under HITECH. Timing of notification, especially if the BA is considered an agent of a covered entity, is of particular importance. BAs are much more likely to fail compliance activities like having written policies and procedures in place with regard to the current HITECH requirements. There's also increased non-compliance penalties. The NPRM proposes substantial increase in the dollar amounts of penalties, and there's more emphasis on the level of culpability. And the amounts of the fines and penalties are going to be based a lot on reasonable cause and reasonable diligence. So the last, basically, an entity has in place, the more they will likely have to pay in fines and penalties. The willful neglect aspect is going to be examined very closely. So if it doesn't look like an entity has even tried to be in compliance, then you will be showing or demonstrating willful neglect. State attorneys general are now actively enforcing HIPAA and Hi-Tech for all entities that are handling protected health information. For example, on July 6th of this year, the Connecticut Attorney General announced a settlement with HealthNet and its affiliates for HIPAA violations. Now, the settlement will cost HealthNet right around $2 million total in cash, plus they have to do ongoing activities that the Attorney General will be monitoring closely for at least the next 2 years. For now, there are more enforcers. So just think about it. The Attorneys General in each state are now going out and ensuring HIPAA Hi-Tech compliance is currently taking place. So they aren't waiting for the results of any final NPRM statements. There is also more motivation to enforce because of the new ways in which those turning in non-compliant entities will be rewarded. And there will also be more resources to pursue violators, not only through all the state attorneys general offices, but also the Department of Health and Human Services has been ramping up its numbers of compliance auditors over the months. So that shows that they're planning to take more action as well. Through the 1990s, I was responsible for information security and privacy within a large multinational healthcare insurer and financial organization. I not only had to remain diligent to address all the information risks throughout our organization, but I was also responsible for ensuring our agents, brokers, and other business partners adequately protected their systems and information. And I found a lot of practices that could have, and actually sometimes did have, bad effects on my organization. For example, one of the brokers had his laptop, which he attached to our network via a VPN, also connected to the internet through another connection, and he did not have any firewall or any malware protection on his laptop. Why? Because he had uninstalled it. Why did he do that? Well, he told me he didn't like how it slowed his system down. So basically his laptop created a direct path for any bad things from the internet to get to our corporate network. During the past decade, I've also found significant security and privacy problems while doing over 200 business associate information security and privacy program reviews. For the next few minutes, I want to point out some of the common problems that I've found over the last couple of decades to help you identify if they exist within your own organization or within your business associates organization, and then help you to address them. Information security and privacy responsibilities need to be formally assigned and documented. Now, not only is this a requirement under multiple rules and regulations, including HIPAA and Hi-Tech, it's also just good business practice to ensure personnel know their responsibilities with regard to security and privacy practices. A formally documented responsibility must be in place to ensure security is appropriately and consistently addressed. This is a HIPAA and Hi-Tech requirement that exists right now. Over the course of doing all of those security and privacy program reviews, I found that there's probably around 35 to 40% of the organizations that had told me they did have policies and procedures in place, but when I asked to see the documents, they didn't actually have those policies and procedures documented. Now, you cannot demonstrate that you have policies unless they're actually documented. You risk noncompliance with many laws by not having formally documented policies and procedures. If you have a regulatory auditor knock on your door to do a HIPAA Hi-Tech audit, I can guarantee that they will ask to see your documented policies and procedures. You need documented policies and supporting documents to be in place now. The weakest link in security and privacy is people. Informed and aware personnel are countermeasures against security incidents. Training and awareness is a prime factor in an organization's successful security and privacy compliance program. Now, many laws and regulations explicitly require formal ongoing training and awareness. Not only HIPAA and Hi-Tech, but also many other federal, state, and local level laws, regulations, and even industry standards. A large number of the organizations whose programs I've reviewed have not had a formal training and awareness program. And the organizations whose programs I've actually reviewed oftentimes had a lot to be desired and were not that effective. For example, one organization simply copied and pasted the entire actual regulatory text of HIPAA into a few hundred PowerPoint slides. Then they put it on a shared folder for their organization and sent a message telling the personnel to go out and look at it. And they called that their training. But this is not training, and it would not be considered to be training. In many other organizations, I found absolutely no training and no awareness communications or events at all. Not only does this put information at risk of incidents resulting from lack of knowledge and having more mistakes, but it's also a significant non-compliance infraction. HIPAA, HITECH, and most other regulations require ongoing training and awareness to be occurring right now. Compliance is not a single point-in-time event. Just think about it. Your business changes constantly. You provide new services and new products. You discontinue services and products. You offer them in new ways, such as online and over the phone and in kiosks. You obtain customers in new geographic locations. There's new types of information collected from your customers and your employees. You make partnerships with new businesses in geographic locations where you've never been before. And then think about all of the new laws that seem to be enacted on an ongoing basis, and the list goes on and on. Now, during these business changes, your compliance levels will also change as a result. You need to stay diligent with maintaining compliance, not only because it's a sound business activity to ensure information security and privacy, but also because the regulators expect for you to stay in compliance at all times throughout all of those business changes. You must be able to demonstrate that you are following all reasonable due diligence activities to remain in compliance with your applicable legal obligations. Now, this certainly applies to HIPAA and HITECH, which also requires that the compliance be monitored. The Business Associate Agreement is a long-standing requirement under HIPAA. It's a legally binding document. However, in many to possibly most of the organizations I've reviewed, I found that the Business Associate Agreement never even left the legal or acquisitions area. So the area responsible for information security and privacy had never seen what the contracts required them to do. So how can you be in compliance with a contract if you've never even looked at the contract? Simply having a BA agreement is not being in compliance, and it does not provide any type of information or privacy security just on its own. It must be communicated to those who are responsible for securing information and then acted upon. BA agreements must also be updated as a result of HITECH and the recent NPRM. So organizations need to be in compliance with their existing BA agreements right now. Improper disposal of sensitive information. Now, this has been a long-time problem at basically all types of organizations, long before there were any legal requirements to dispose of information securely, and clear up to this day, and it will continue to be. Now, one of the activities I do for on-site reviews is an after-hours facilities and work area review to see what kind of information security risks I can find just by walking through a facility. And I've always found sensitive documents or items with sensitive information, such as thrown away USB drives or prescription bottles with the patient information intact on the bottle somewhere in the open trash cans. Now, my sons recently assisted me in doing some light dumpster diving in the West Des Moines, Iowa area, meaning we didn't actually dig through like the outdoor public receptacles. This is what the crooks would do. But we simply looked into the dumpsters to see what was visible. And we easily saw personal information on documents and also on other items in a large portion of the public dumpsters outside of banks, small businesses, and strip mall type settings, on university campuses, outside of restaurants, and at small medical clinics. HIPAA and HITECH require organizations to securely dispose of personal information. Significant sanctions of millions of dollars have already been given for not doing so. So these secure disposal practices need to be in place right now. Many of the business associate organizations I've reviewed have subcontracted certain information processing activities to yet another company. Now, many times this is done without the knowledge, let alone approval, of the covered entity. And in most cases, there was not a BA agreement in place, which is a HIPAA noncompliance issue. Now, the more hands and more entities that touch PHI, the more risks that exist to the PHI, and the more likely the noncompliance situations, in addition to privacy breaches, that will happen. And they've happened quite often over the years. A significant added responsibility HITECH brought to covered entities and business associates was the requirement to have privacy breach response plans and training in place. HITECH created a significant federal requirement in addition to the at least 49 state and territory level breach notice laws that exist. Now, it's worth pointing out that HITECH significantly expanded the types of personal information that is covered beyond those 49 laws, most of which were limited to just a handful of information items. HITECH now requires response notices if risk analysis following an incident shows a likelihood that any of the 19 types of named protected health information items is accessed or used in an unauthorized manner. Most of the organizations I've reviewed did not have documented breach response plans, but these need to exist right now. Most information security and privacy laws and regulations require a large amount of documentation and activity logging. This documentation provides evidence of what the organization is doing, and it demonstrates due diligence to protect information as well as to meet the compliance requirements for such logging and documentation. Unfortunately, documenting and logging is not a fun thing to do, and it can take time and resources, and so what happens is it often is not done. Now, there have always been problems with documentation and activity logs in the information security and privacy program reviews I've done. Some of the organizations thought that they were creating logs when in fact they weren't because of the way that they had implemented their system's settings. Now, HIPAA and HITECH explicitly require information security and privacy logs to be maintained in addition to documenting policies, procedures, and data protection activities, such as keeping logs of breaches. It would be hard to find a company today where personnel were not using some type of mobile computer, smartphone, or electronic storage device while doing work activities. Large amounts of sensitive and confidential information can be, and often is, stored upon these devices. These mobile computers and storage devices are very easy to misplace, to lose, or forget, and they are a favorite target of thieves. Appropriate security needs to be in place to protect them, and there also needs to be protection for the information stored on them. A large portion of the business associates I reviewed did not have security or privacy controls or policies or procedures in place for these types of mobile computing devices. These types of protections need to be in place now. Another type of incident that is reported weekly and sometimes daily is the loss or theft of personal information that was not encrypted. Now, I found most of the business associates and vendors I've reviewed do not use encryption to protect information in storage, in transit, or on mobile computing media and devices such as laptops, smartphones, backup tapes, and so on. Now, this is slowly changing, but in most cases, organizations do not want to spend the time and resources to encrypt data unless it's required contractually or by law to do so. So be sure encryption is used to mitigate the risk involved in these types of situations. This applies to information not only in storage, but also in transit and also moving through and between networks. A large portion of organizations still do not have any documented business continuity or disaster recovery plans. In far too many cases, business continuity and disaster recovery plans are often either missing or they were written several years ago and never tested. A couple of years ago, I found an organization, and they had a really well-documented and detailed business continuity plan, and it was from 1995, and they had never updated that plan. Now, needless to say, most of their systems and applications had either been replaced or changed dramatically since that time. HIPAA and HITECH require organizations to have up-to-date business continuity and disaster recovery plans in place, and then they need to test them regularly. Many of the organizations I've worked with have said in one way or another upon initially meeting information security and privacy compliance, whew, I'm glad I've got that compliance stuff taken care of. Now I can forget about it and go on to other things. But please be sure that once you meet compliance, you follow a plan, a structured plan to stay in compliance with all the requirements. As I mentioned earlier, your business changes constantly, and during all these business changes, your compliance levels will also change as a result. You need to stay diligent with maintaining compliance not only because it's a sound business activity to ensure information security and privacy, but also because the regulators expect for you to stay in compliance at all times. You need to have a good plan in place to keep track of your compliance, or you could pay dearly for it in fines, penalties, or civil suits. And now I'm going to turn it over to Anupam to discuss how to manage all your security and privacy compliance activities. So let me pass it over to you here now. There.
Thank you, Rebecca, for the nice detailed overview on HIPAA, HITECH, and how it's going to affect all organizations. So my name is Anupam Sahai. I'm the co-founder and president of eGestalt. And as Rebecca talked about the fact that there is an increasing need to become HIPAA compliant, HITECH compliant, and along with that there's a huge degree of confusion around, so what does it mean for me as an organization to be HIPAA HITECH compliant? How do I assess what my current status is, and what do I need to do or put in place to become HIPAA compliant? So we've been talking to a number of customers about this problem, and of course not just HIPAA but PCI and other regulations. And eGestalt launched a tool called Secure GRC in June of 2010, and that tool essentially addresses a number of the automation and compliance regulation related issues that were brought up. And I'll take you through the tool, the benefits, what it does, capabilities, etc., and how you could use Secure GRC for all your security and compliance management needs as pertinent to HIPAA. So what is Secure GRC? Secure GRC is a cloud-based software as a service solution that enables you to become compliant, and it looks at compliance from a holistic view wherein it combines security monitoring and compliance management. And as I'll go through the presentation, you'll see that even if you're secure, it does not mean you're compliant, or if you're compliant, it does not beget security. So it's important to look at security and compliance in a unified way, and it's an ongoing process. Compliance is an ongoing process. It's not a one-time destination. So our solution is delivered through the cloud. We have a virtual software appliance that sits on the customer premises, which does a number of activities such as data discovery. It assesses your real-time security and compliance status, and all the results are uploaded to the cloud. And our go-to-market strategy is focused on delivering the solution through channel partners, whether it's MSPs, managed service providers, or security service providers, or compliance and auditors that already work with the organization. And they will essentially use the tool to provide you with a managed compliance service. As you can see, we've been recognized in the industry by a number of awards as being a very innovative product in this category. So why is there an increased need to become compliant now? There are a couple of market drivers that are happening right now. One is the number of regulations and the enforcements are going up dramatically. As Rebecca talked about, HITECH brings in a lot more enforcement capability and a lot more fines. In some cases, executives can go to jail. And so there's a lot of enforcements happening. There are a lot more regulations that are being put in place either by the government or through standard bodies like PCI. And the cost of becoming compliant and maintaining compliance is very high. So the choice is between dealing with compliance needs by paying high cost to be compliant or face penalties and jail. And really, the situation is pretty grim right now. Otherwise, the other dimension is that the cyber attacks and cybersecurity threats that are happening. The recent Verizon breach report mentions that 91% of the breaches took place through organized crime groups, and about $1 trillion have been lost in the last 5 years by large corporations as a result of these data thefts and security thefts. So compliance regulations and security threats are increasing, and there's a big need to address it. And the good news is that technology exists. A bit more color on the regulatory penalty system that Rebecca talked about. Now there are different tiers of penalties that businesses face if they are willfully neglecting it, or if they are willfully neglecting it and not correcting it, or correcting it. And the fines can go up to $1.5 million per year. Also, in terms of the changes with respect to the HITECH Act, there are a number of new game changers, essentially putting the burden of being compliant on the covered entities and the business associates. The enforcement agencies get to keep the fines, so they have increasing motivation to enforce it. And the entire value chain of the medical providers, covered entities, such as business associates and their contractors, are now covered under the purview of the HIPAA HITECH enforcement law. So how can Secure GRC help? So one, it can help in many ways. Firstly, as an organization, as a business, we want to figure out what is my compliance status? How far am I from being compliant? And how do I get to a point from where I am to becoming compliant? So Secure GRC has a set of tools. I talked about a software appliance that sits on the customer premises. It looks at all the servers, databases, all the records that are available, and gives you an assessment, real-time assessment of the current compliance status. And then through a process of remediation, through a process of workflow management, it manages the entire process of becoming compliant while giving you constantly a real-time dashboard view of your compliance status. It also looks into security threats, security vulnerabilities that might exist in your environment, and how that maps to HIPAA regulations or other compliant regulations like PCI and others. So it kind of looks at security vulnerability, security monitoring issues, and maps it to compliance regulations. Also, out of the box comes complete set of regulations, whether it's HIPAA, PCI. We have 10+ regulations that are most commonly required. It's available out of the box. You have built-in questionnaires and automation tools that enable you to become compliant, know where you stand with respect to the compliance status. So you don't need to spend lots of time manually using spreadsheets, managing and editing your compliance status, which is currently the case. It essentially makes compliance an ongoing real-time assessment process with a dashboard view, and it changes the mindset of compliance from, oh no, we have an audit, to an ongoing process with a state of calm. A high-level overview of what the Secure GRC framework looks like. On the left-hand side, we have a number of inputs. Secure GRC takes the outputs of third-party scanners that are out there, vulnerability scanners, application scanners. It looks into the IT configuration in terms of how your network has been designed. It has a built-in questionnaire. It looks at log information. And also it has something called a compliance scanner, which is essentially data discovery of compliance-related issues in the customer premises. And it takes all that input, assesses the current compliance and security status, and then manages the entire process from discovering the gaps in compliance and managing the remediation process till you get compliant. And on the right-hand side, the output of the solution is a set of dashboards or reports, or you can export the data. And also you have assessment and evaluation of the business risk at any point in time for the organization. A bit more detail. So as I said earlier, the solution has built-in mechanisms for compliance risk data gathering. It maps it to regulations through a combination of automation wherever possible and partly manual processes. It has the ability from the HIPAA point of view to assess your compliance status, understand how security threats and vulnerabilities might be impacting your compliance, and then it can also act as a document repository to store your processes and asset information and compliance status and keep a trail, audit trail of all the information that you might need or the auditors might need. The reason why we are cloud-based brings in a number of benefits. There's no hardware costs required to deploy. There's no upfront investment. Maintenance is essentially not required because you deliver it through the cloud. It's always updated. We have hardened security mechanisms, and we also have what we call pay-as-you-grow consumption model. So you only pay for the modules and the scale that you need at any point in time. As your business needs grow, as number of users grow, as your company size grows, the pricing model and the architecture scales up to deal with it. And we have backed up security and compliance expert services that can guide you through it if you need help. So I want to take you through the system a little bit, give you a feel for how the system looks like. This is a dashboard view of Secure GRC. As you can see on the left-hand side, you have a snapshot of all the compliance status today at any point in time. You can look into the different categories of risk. You can click and dive into the details of what specific items are causing the risk exposure, and also look at the number of controls that are in place, etc., etc. And at any point in time, you can look at the remediation process, the gaps that exist, and what is causing those gaps to happen. And this dashboard, by the way, is totally customizable, and you can tune it to your organization needs. And then, as I said, you can click on any particular link and dive into the details of the compliance status. There are a number of other tabs in the tool which allows you to look at how to manage the compliance process, how to delegate the compliance process to different organizations. We have something called a compliance scanner, which is really an automated way of discovering and assessing your compliance and security status. And essentially what it does is it kind of takes into account your firewall configuration. It takes into account, it takes the input of multiple network scanners, web scanners. It also looks into your computer storage devices to look for any confidential data that should not be there, whether it's PHI, health information, or credit card data in case of PCI, etc., etc., and also looks into Active Directory for willful credentials, access to resources. So it takes into account all those information, the compliance scanner, and basically in this case it's taking as input the Nessus scanner, and you can also provide input to the SQL server or databases or computer IP addresses, and the result is that it takes all that information, does the automatic discovery, scanning, and assessment, and then maps it to HIPAA regulations to figure out where your exposure is. So for example, in this case, you're seeing that the compliance scanner results is mapped to a set of HIPAA regulations where one of the columns is it's in place, it's not in place, and in this case it's saying that security management process and risk analysis is not in place, and hence there's a need to look at that and dive deeper and understand what the implications could be. The tool also enables creation of assessments which you could use, that's available in the box, out of the box, from Secure GRC, or you can customize it and edit it and add details pertinent to your business. So it's totally configurable and tunable based on your requirements. You can add new questions. You can send out assessments to anybody in the organization, and they can fill out the questionnaire, answer the questions. All the results are sent back to the administrator, and the results available online at any point in time. And the remediation tab enables you to look at any point in time the status of the gaps, remediation status, which compliance gap exists, who's responsible for addressing those compliance needs, and if necessary, they will send reminders to the person or to their bosses included to ensure that these are addressed in a timely manner. At any point in time, you can review the compliance status. You can look at the controls that are in place, not in place, and then kind of drill down into figuring out who's responsible for which controls so that you can remediate it and go after and make that closure happen. And the risk status is also available in real time at any point in time so that you're aware of the compliance status. The system can also generate different kinds of reports. It can generate gap reports, it can generate activity report, or it can generate reports that can be used by an auditor to certify HIPAA compliance. So the tool has built-in capability to manage the compliance process end to end, and the output is a set of reports that the HIPAA auditor can take and do the follow-up necessary thing. Reports can also be exported in any format that you like, PDF, Excel, and reports basically highlight in a very summary fashion what the gaps are, or if it's an activity report, it'll tell you the full detail. The tool supports multiple regulations. Certainly HIPAA is one of the key regulations, but supports PCI, ISO, NIST, and other custom regulations that might be of interest to you. So Secure GRC, as I mentioned earlier, looks at security and compliance in a unified fashion. Our cloud-based model enables us to deliver a unified solution using a very cost-effective manner. Our solutions are available through our channel partners that I talked about, and because of the cloud-based delivery model, because of no hardware requirements, there's no upfront investment required to buy the tool. You pay for what you need and pay as you grow in terms of the solution. So in summary, as I mentioned earlier, HIPAA compliance is a journey. It's not a destination. It's an ongoing process. It's a continuous process of being on top of your HIPAA status, making sure the gaps are being remediated, looking at security status and making sure the security threats and vulnerabilities are not exposing and affecting your compliance status. And it's important to look at security and compliance in a unified manner. I mentioned about Secure GRC can be used as a tool to assess your requirements, assess your HIPAA compliance status, and then continue to make HIPAA compliance happen in the organization. So it also acts as a data repository, and it's important to build a data breach response plan, which is now part of the HIPAA requirements as well. And the tool can help you through documentation to create and to archive the audit trail as the organization proceeds to becoming compliant. So, Rebecca, do you want to add anything to the closing remarks before we open it up for questions?
Sure. Yeah, thank you. I think also it's important for everyone listening to make sure they aren't waiting to do something to see what the final result of the NPRM that came out in July is, because basically the HITECH Act is effective now with regard to all those requirements that went into effect throughout 2009 and 2010. HIPAA, Security Rule and Privacy Rule, has been out there for 14 years now. So there's a lot of those requirements that you have to have in place now. You shouldn't be waiting for it. Along with the BA agreements, those you need to make sure that you've done actions to be in compliance with them. And then very importantly, the state attorneys general offices are already taking action because they feel that The rules have been out there for 14 years. They consider it an industry standard that all organizations that have PHI are implementing protections now. So you don't want to wait around in order to put safeguards in place. And you need to make sure you go ahead and get started, because you can't do it overnight either. So I guess that with that, perhaps we can open it up to other questions.
Great. Yep. Thank you, Anupam and Rebecca. The webinar was really informative. We have a couple minutes for questions, and we have some lined up already. So if you guys are ready, I'll ask these.
Sure.
Okay. The first question. If I have my applications installed in a remote data center, how does the product ensure compliance?
So I guess that's a question for me.
I think so, yeah.
Yeah. So we have a questionnaire and assessment procedure built in for application security and privacy requirements. And so if the application is sitting in a remote data center, we have to basically ensure that the application requirements, assessment requirements are met by that application. So by looking at that questionnaire, answering the questions, and running the real-time assessment tool, that can be determined and assessed very easily.
Okay, great. Thanks, Anupam. Next question. Well, there's been some questions about slide decks and recordings. We'll have the recording available on egestalt.com. That should be available in a day or so. And for slide decks, they can email either of you. Is that correct?
Yeah, we can just send me an email, and I'll send the deck across to you.
Okay, great.
Or Rebecca, either way.
Sure.
Next question. Let's see. Is it a requirement to encrypt data on a private WAN provided by a company like Cox or Verizon?
Well, the question of encryption is a good one, because there's so much misinformation out there and there's so much confusion. Now, HIPAA requires that you encrypt data if, as a result of a risk analysis, it shows that you need to in order to limit access to that data and protect it. Now, there's certain situations where, even though HIPAA might not explicitly say you have to encrypt it, such as when you're sending it via email through the Internet, if you would do a risk assessment of all the bad things that can happen to clear text email information going through the Internet, it would be something that it would be expected that you would encrypt PHI and clear text email messages. Now, for a wide area network that's on a private network, it would depend upon many different factors, but you would have to look at who all has access on that wide area network. Are you a covered entity? Are you a hybrid entity? And a hybrid entity means that you have portions of your organizations that are doing business activities that are not covered by HIPAA. So it explicitly requires that in a hybrid entity you have those activities protected and separated, and if the data is going outside of that protected and separated area to areas where the rest of the organization could get access, then encryption may be your best solution. So unfortunately, even though I know a lot of organizations want to have, just an answer that says, yes, you always need to encrypt it here, or no, you don't, HIPAA itself does not have that type of explicit wording. But if you look at what is best and has been learned over the years with regard to breaches and industry practices, there are many situations where it would make sense that because the risk is so high that the data should be encrypted, such as in mobile storage devices and going through open networks. When you get into private networks, that's where you need to do more risk analysis to find out the true risk factors involved.
Okay, great. Thank you. We've actually run out of time, but we have a lot of questions left. What we're going to do is Anupam and Rebecca will answer each of these offline to the individual that asks them. And that should work, right, guys? Is that okay with you? Okay, great. Well, thank you, everybody, for joining today's webinar. And thank you to Anupam and Rebecca. Like I said, the webinar will be available on egestalt.com. And if you have any questions or want to contact Rebecca or Anupam, feel free to email them. And thanks,
Thank
guys,
you
for
very much.
presenting. Thank you. Bye-bye.
Thank you very much.